The United States Plaintiff Appellee versus Pablo SUAN as the defendant appellant. Perfecto Salos Rodriguez for appellant and Solicitor General Harvey for appellee. This is for the crime of seduction. Chastity of the female as an essential element. An essential element of the crime of seduction is that the female must be chaste not only by reputation, but as a matter of fact up to the time of the alleged seduction. If prior to that time she has voluntarily has sexual intercourse with any other man, the defendant cannot be convicted of seduction. Facts of the case. This is an appeal by the defendant Pablo SUAN from the judgment of the Court of First Instance of Palawan convicting him to the crime of seduction. Anisita Saldivia, the offended party, testified that she was 14 years old and that in 1911 she was a pupil in school of Coron, Palawan, and that Pablo SUAN was one of her teachers. That in the month of September 1911, he began making love to her and promised to marry her. That after the engagement in the following month, he began having sexual intercourse with her. That she had intercourse with the defendant many times during the period of 7 months. That after she became pregnant, the defendant stopped coming to her house, and that in June 1912, she gave birth to a child. This testimony of the girl is true. The defendant showed conclusively that the offended girl had illicit relations with various young men at various times before he had carnal relations with her. The issue is whether or not the defendant is guilty of the ruling of the case. Paragraph 1 of Article 443 of the Penal Code, under which the defendant was convicted and sentenced, reads as follows. The seduction of a virgin over 12 and under 23 years of age, committed by any person in public, authority, priest, servant, domestic, guardian, teacher, or any person who in any capacity shall have charge of education of the woman seduced, or shall have her under his care, shall be punished by prison correctional in its minimum and medium degrees. The general rule is that unmarried females who are virgins are virtuous, and those who, by their own consent, have ceased to be virgins are not virtuous. The authorities seem unanimous that prior absolute chastity on the part of the woman is an essential element of the crime of seduction, especially so when made a request by the express words of the statute. As we have seen from the matter of physical conditions of past conduct of actual purity. The fact that the man may have considered her a virgin does not seem to change the rule. His ignorance of her previous immoral and unchaste practices cannot make her a virgin in the eye of the law. Therefore, the defendant did not commit the crime of seduction. The judgment appealed from is reversed and the defendant is acquitted with cause de officio.